Objection, Your Honor. I need to withdraw from this case, effective immediately. Every head in courtroom 14 turned at once. The jury froze. The prosecutor lowered his pen. Judge Harold Sutton, who had presided over criminal trials for 23 years and believed he had seen everything a courtroom could produce, looked up from his bench with an expression that was not anger, not surprise, but something rarer, genuine confusion. The woman who had spoken was Victoria Cross, 41 years old, senior partner at Cross & Merritt, one of the most respected criminal defense firms in Chicago. In 16 years of practice, she had never lost a trial, not one. She had defended corporate executives, city officials, a sitting congressman, and a man the entire country had already decided was guilty. And she had walked every single one of them out of that courthouse free. She had never once in 16 years stood up in the middle of a trial and asked to quit. The man sitting beside her, her client, a quietly dressed accountant named Stephen Pratt, charged with the murder of his business partner, turned and stared at her with an expression that was not confusion at all. It was fear. Ms. Cross, Judge Sutton said slowly, I am going to need you to explain yourself. Victoria looked at the, judge. Then she looked at Stephen Pratt. Then she reached down, picked up her briefcase, set it on the table, and said 5 words that no one in that room had expected to hear from the most winning defense attorney in Illinois. My client has been lying. Stay with us. Because what Victoria Cross discovered and what it meant for the person she had been hired to protect is the kind of story that reminds you exactly why the truth always finds its way into a courtroom. Subscribe to Sweet Justice right now. You are going to want to be here for every second of this one. To understand what drove Victoria Cross to that moment, standing in a packed courtroom betraying the most sacred obligation of her profession, you have to go back 4 months to the evening she first met Stephen Pratt. It was a Thursday. Victoria had been at her desk until 9, working through a filing deadline, when her assistant knocked and said there was a man in the lobby who had asked for her specifically. He had no appointment. He had simply shown up and said he needed the best criminal defense attorney in Chicago, that he had been told that was Victoria Cross, and that he was prepared to pay whatever it cost. Victoria had almost sent him away. She was tired. She had 3 active cases. She did not need a walk-in, but something made her go to the lobby. Later, she would describe it as instinct, the kind that had served her well for 16 years, and that she had learned the hard way to listen to. Stephen Pratt was 44 years old, medium height with the slightly rumpled appearance of a man who was normally very neat and had recently stopped caring. He sat in the lobby chair with his hands on his knees, a leather folder on the seat beside him, and the look of someone who had been awake for a very long time. He stood when Victoria entered and said without preamble, "My name is Stephen Pratt. My business partner was found dead in our office 3 days ago. The police think I did it. I did not." Victoria had heard that sentence, or a version of it, more times than she could count. She had learned that the sentence itself meant nothing. The truth of it was always somewhere in the details. She said, "Come into my office," and spent the next 2 hours listening to everything Stephen had to say. His business partner was a man named Daniel Cho. They had co-founded an accounting firm 12 years earlier, grown it from 2 people in Mayo, a rented office, to a 40-person practice with a client list that included several mid-sized corporations and a handful of individuals whose names appeared regularly in the business press. By every external measure, the partnership had been a success. By Stephen's account, the last 2 years of it had been a quiet, grinding disaster. He said that Daniel had begun making decisions without consulting him, moving client funds in ways that Stephen could not trace or justify, withdrawing from their joint operating accounts in amounts that were never recorded against any invoice or expense. He said he had confronted Daniel about it twice. The first time, Daniel had laughed it off. The second time, 3 weeks before Daniel died, he had looked at Stephen across the conference table and said very quietly, "You don't want to know what I know about you, Stephen, so let's both stay in our lanes." Stephen did not know what that meant. He said it had frightened him. On the evening Daniel died, Stephen said he had been in the office late, alone, working, after everyone else had left. He said Daniel had come in unexpectedly around 8 o'clock. They had argued again about the accounts, and Daniel had left. Stephen said he left himself an hour later. The following morning, the cleaning staff found Daniel's body in the conference room. He had been struck from behind with a glass award, a heavy thing, the kind given at industry ceremonies, that sat on the shelf above the conference table. It had been wiped clean. There were no fingerprints. There were no witnesses. There was, however, footage from the building's security system showing Stephen's car in the parking garage until 11:17 that evening. More than 2 hours. After he claimed to have left, the police arrested him 6 days later. Victoria had listened to all of it. She had asked precise questions. She had noted every inconsistency and every detail that felt solid. When Stephen finished, she looked at him for a long moment and said, "Is there anything else you need to tell me? Anything at all that you have left out because you thought it was unimportant or because you were afraid of how it would sound?" Stephen met her eyes. He said, "No, that is everything." Victoria took the case. She spent the following 3 months building a defense around the security footage. The footage showed his car, not Stephen himself. It was entirely possible that his car had remained in the garage while Stephen left on foot, through an exit that the cameras did not cover. She located a witness, a food delivery driver who operated in the area, who said he had seen a man matching Stephen's description leaving the building on foot around 9:15. She challenged the forensic timeline. She identified 3 other individuals who had access to the building that evening and had not been thoroughly investigated by the police. It was a strong defense. Not airtight. No defense built on absence of evidence ever was, but strong enough that Victoria had gone into trial with confidence. She had won cases with far less. And then, on the evening of the 3rd day of trial, something happened that changed everything. Do not move. Subscribe to Sweet Justice if you have not already, because what Victoria found that evening is the turn this entire story pivots on, and we are just getting to it. Victoria had a habit, developed over 16 years, of reviewing every document in a case file at least once more the night before a critical witness took the stand. The following morning, the prosecution was scheduled to call Daniel Cho's personal assistant, a woman named Rita Fong, who had worked for Daniel for 6 years and who the prosecution believed could establish that Stephen had made threatening statements toward Daniel in the weeks before his death. Victoria was reviewing Rita's deposition transcript when she noticed something. A small thing. A date. Rita had stated in her deposition that the last time she had seen Daniel alive was the afternoon of the day he died, that she had left the office at 5:30 and Daniel had been at his desk. She had described what he was wearing. She had described the conversation they'd had about the following day's schedule. She had been specific, consistent, and entirely believable. But in that transcript, Rita mentioned that Daniel had been on a call when she left, a call that he had taken on his personal cell phone, stepping away from his desk to take it privately. Victoria had read that detail before. She had not thought about it. But tonight, reading it again, something tugged at her. She pulled Daniel's phone records. They had been provided in discovery and she had reviewed them weeks ago. She went back to the evening in question and looked at the calls between 5 and 6 o'clock. There was one outgoing call at 5:22 lasting 4 minutes. The number it connected to was a prepaid cell, untraceable. She had noted it before and moved on. Tonight she did not move on. She sat with it. And then, on impulse she could not entirely explain, she cross-referenced the number against Stephen's call records. It was not in Stephen's records, but it was in the records of an account associated with Stephen's home address. A second line. One that had never come up in any disclosure. One that Stephen had never mentioned. Victoria stared at her screen for a long time. She called the number from her own phone. It was disconnected. She tried to trace the account registration. It had been opened under a name she did not recognize and closed the day after Daniel died. She sat in her office until 2 in the morning. Then she picked up the phone and called Stephen. He answered on the second ring. She said, I need you to tell me about the prepaid number registered to your home address. The silence that followed lasted 11 seconds. She counted. Then Stephen said, "I don't know what you're talking about." Victoria said, "Stephen, I have been a defense attorney for 16 years. I know what a lie sounds like at 2 in the morning. I am going to ask you one more time. Tell me about the number." Another silence, shorter this time. And then Stephen Pratt told her the truth. What Stephen told Victoria over the next 40 minutes was not the story she had been hired to defend. It was a different story entirely, one with the same people and the same ending, but a completely different middle. Daniel Cho had not simply been moving client funds. He had been systematically embezzling from the firm's largest client, a corporation whose accounts Stephen and Daniel jointly managed, for almost 3 years. The total amount was close to $4 million. Stephen had discovered it not through his own investigation, but because Daniel had told him. In the second confrontation, the one where Daniel had said, "You don't want to know what I know about you," Daniel had also revealed what he had been doing, as a form of mutual assured destruction. He had evidence, he said, that Stephen had signed off on several of the earliest transfers. Forged evidence, Stephen insisted, but evidence nonetheless. If Stephen reported him, Daniel would take Stephen down with him. Stephen had not reported it. The prepaid phone had been Stephen's way of trying to find a solution that did not involve the police or the firm's clients. He had been in contact, through that number, with a private financial investigator he had hired to find the money and quietly return it before anyone noticed. That investigator had been making progress. And on the evening Daniel died, the call Daniel took on his personal cell, the call Rita Fong had witnessed, had been from that same investigator. Somehow, Daniel had obtained the number. He had called it himself. He had learned that Stephen had hired someone. And he had come into the office that evening not just for an argument but for something else. Stephen said he did not kill Daniel. He said that was still the truth. He said Daniel had been alive when he left. But he acknowledged, in a voice that had lost all of its steadiness, that everything he had told Victoria about the context of that evening had been incomplete. He had withheld the embezzlement. He had withheld the investigator. He had withheld the phone. Because if those things came out, his motive became overwhelming. He had not just been an irritated business partner. He had been a man with 4 million reasons to want Daniel Cho to disappear. Victoria listened to all of it. She said nothing for a long time when he finished. Then she said, "Stephen, do you understand what you have done?" He said, "I was trying to protect myself." She said, "You hired me to protect you, and you did it by lying to me about the thing that matters most. You gave me a case to win and hid the part that could lose it." In the morning, Victoria Cross stood up in Courtroom 14 and said what she said. Now, here is where this becomes something even more complicated than a straightforward courtroom drama, because what happens when an attorney discovers her client has been lying is not simple, and it is not governed by instinct alone. It is governed by a specific and demanding set of professional ethics that Victoria understood better than almost anyone. She could not continue to present a defense she now knew was built on a foundation of deliberate concealment. She could not put witnesses on the stand to support a version of events her client had told her was false. But she also could not walk into that courtroom and simply tell the judge what Stephen had told her, because the conversation in her office at 2 in the morning was protected by attorney-client privilege. Stephen had told her the truth. She could not use it against him. What she could do, what the rules of professional conduct permitted and in her judgment required, was withdraw, remove herself from the case, allow Stephen to obtain new counsel, who would begin with a clean understanding of the full facts. Leave the decision of what to do with the truth in the hands of Stephen himself and whoever came after her. That was the only ethical path available to her, and it was the one she took. Judge Sutton recessed the trial for 48 hours following Victoria's withdrawal. The jury was instructed in careful language to disregard the circumstances of the change in counsel and to draw no inference from it. Whether that instruction held any power over 12 human beings who had just watched the defendant's own attorney stand up and ask to leave mid-trial was a question none of the attorneys involved could answer with confidence. Stephen. Pratt was appointed temporary counsel, a public defender named Marcus Green who was, by any measure, competent and experienced, but who had inherited a case he had not built, a client whose credibility had just been publicly shattered, and 48 hours to prepare for a cross-examination of Rita Fong that Victoria had spent 3 weeks planning. Subscribe to Sweet Justice right now, because the moment Marcus Green walked into the holding cell to meet Stephen Pratt for the first time is when this story takes a turn that nobody in that courthouse expected. Marcus sat across from Stephen in the holding cell, with a legal pad and a pen, and said simply, "Tell me everything, from the beginning, leave nothing out." Stephen looked at him for a long moment. Then, perhaps because he had already lost the most formidable attorney in Illinois by telling half the truth, or perhaps simply because he was exhausted, he did something he had not done with Victoria until 2 in the morning of the 3rd day of trial. He told Marcus everything, immediately: the embezzlement, the investigator, the phone, all of it. Marcus listened. He wrote. He asked 2 questions. The first was the location of the private financial investigator. The second was whether Stephen had ever at any point been physically alone in the conference room with Daniel Cho on the evening he died. Stephen said the investigator's name was Frank DeLuca, based in Milwaukee, and he said no. He had never been alone in the conference room with Daniel that evening because when Daniel arrived and the argument began, there had been a 3rd person present. Someone Stephen had not mentioned to anyone. Someone who had been there by chance, not design. A junior associate named Kevin Walsh who had been working late in a back office and had come to the conference room doorway during the argument and stood there, visible, before backing away and leaving. Marcus stared at him. He said, "Stephen, why did you not tell anyone about Kevin Walsh?" Stephen said, "Because Kevin saw how angry I was. I thought it would make me look worse." Marcus put down his pen. He looked at the ceiling for a moment. Then he picked it back up and said, "Kevin Walsh may be the only thing that saves you, because if he saw you leave that room before Daniel was killed, you have a witness, and right. Now, you have nothing." Marcus Green filed an emergency motion the following morning requesting a 2-day extension to locate and depose Kevin Walsh as a potential defense witness. Judge Sutton granted it, reluctantly, noting for the record that the unusual circumstances of the case warranted some accommodation, but that he expected no further delays. Frank DeLuca, the private financial investigator, was located in Milwaukee within hours and agreed to provide a voluntary statement. What he said confirmed the core of Stephen's account. He had been hired to trace the embezzled funds. He had obtained Daniel's personal cell number through sources he declined to specify, and Daniel had called him on the evening he died, demanding to know who had hired him. DeLuca had not told him. He had ended the call. He had not spoken to Daniel or Stephen again after that evening. Kevin Walsh was harder to find. He had left the firm 3 weeks after Daniel's death and taken a position at a company in Seattle. When Marcus's investigator reached him by phone, Kevin was initially reluctant to speak. He said he did not want to be involved. He said he had already spoken to the police once early in the investigation, and they had told him his account was not relevant. That single sentence, "his account was not relevant," landed on Marcus Green like a physical thing. Because if Kevin had spoken to the police and the police had decided not to pursue his account, that meant either they had not understood its significance, or they had understood it and made a decision that was going to be very difficult to explain in open court. Marcus flew to Seattle himself. He met Kevin Walsh at a coffee shop near his office on a Tuesday morning. Kevin was 28, quiet, and visibly uncomfortable. Marcus did not pressure him. He said only that Kevin's account of what he had seen that evening could be the difference between a man going to prison for something he did not do and a man going free. He said he was not asking Kevin to say anything other than the truth. He was asking Kevin to say the truth where it could actually matter. Kevin stirred his coffee for a long time. Then he said, "I saw Stephen leave. He walked past the conference room doorway. He had his jacket over his arm and he said goodnight to me. Daniel was still in the conference room. Daniel was alive. I heard him on his phone. Marcus said, "What time was this?" Kevin said, 9:40, maybe 9:45. The building security footage showed Stephen's car leaving the garage at 11:17. That was a gap of nearly 90 minutes. In the prosecution's theory, that gap was when the murder occurred. Kevin Walsh had just placed Stephen Pratt outside that conference room, with Daniel Cho alive inside it at 9:40. Kevin Walsh took the stand on the 6th day of trial. He was calm. He was specific. He described exactly what he had seen. Stephen walking past, jacket over arm, saying goodnight. Daniel's voice audible from the conference room on a phone call. He described his own departure from the building 40 minutes later, and the fact that he had passed the conference room on his way out. He said the light was off. He said the door was closed. He said he had assumed Daniel had left through a different exit. The prosecutor cross-examined Kevin for 2 hours. He challenged his memory. He challenged the lighting. He asked why Kevin had not volunteered this information more prominently. Kevin said he had told the police and they had not seemed interested. The prosecutor asked whether he could be certain of the time. Kevin said he had texted his girlfriend at 9:43 saying he was on his way home, a text that was, in evidence, time-stamped, retrieved from his phone records. The jury looked at that timestamp for a long time. Frank DeLuca took the stand the following morning and walked the court through the embezzlement investigation, the $4 million, the 3 years, the method, and the call from Daniel on the evening he died. His testimony established something the prosecution had not anticipated having to address. Daniel Cho had known, in the hours before his death, that someone was investigating him. That someone, not Stephen, had a very significant reason to want that investigation to stop permanently. Judge Sutton allowed the testimony over the prosecution's objection. He said, "The relevance to alternate suspect theory is sufficiently established. The objection is overruled." The prosecutor stood. "Your Honor, this is speculation. There is no identified alternate suspect." Judge Sutton looked at him. "There is an unidentified one, Counselor, and the jury is entitled to consider whether that matters. Sit down." The prosecution's closing argument leaned heavily on the security footage, the established motive, and the question of why Stephen Pratt had lied to the police, to his attorney, and by omission to the court, if he had nothing to hide. It was a fair argument, a human argument. When someone lies about the circumstances of a murder, the natural inference is not that they were protecting an embarrassing secret. The natural inference is that they were protecting themselves from the truth. Marcus Green's closing was the best work of his career, and he knew it. He stood in front of the jury and said, "Ladies and gentlemen, you have heard a great deal in this trial about what Stephen Pratt did not tell people. I want to talk to you about what he did tell you. Here, in this courtroom, on the record, at the risk of everything. He told you about the embezzlement. He told you about the investigator. He told you about the phone. He did not have to do that. The evidence that surfaced those facts would have come in regardless. He told you because Marcus Green sat across from him in a holding cell and said, 'Tell me everything.' And after everything that had happened, Stephen Pratt finally did. He paused. Let the jury sit with it. Kevin Walsh saw him leave. Kevin Walsh heard Daniel alive. A text message places that timeline beyond reasonable dispute. And somewhere in the hours between Stephen Pratt saying goodnight and that security camera recording his car leaving that garage, someone else was in that building. Someone with 4 million reasons to make sure Daniel Cho never spoke to Frank DeLuca's employer again. You do not know who that person is. Neither do I. But reasonable doubt does not require you to name the killer. It requires only that you cannot be certain, beyond a reasonable doubt, that the killer was Stephen Pratt. He sat down. The jury deliberated for 11 hours over 2 days. They sent out 3 questions. The first asked for Kevin Walsh's testimony to be read back in full. The second asked for the timestamp of Kevin's text message to be confirmed. The third, the one that made Diane Marsh, sitting in the gallery as an observer, lean forward. In her seat, asked the judge the following question in writing. If we believe the defendant is probably guilty but are not certain, what are we required to do? Judge Sutton's response was precise and careful. He instructed the jury in writing that the standard of beyond a reasonable doubt was the highest standard in American law. That probably guilty was not sufficient. That if they entertained a genuine, reasonable doubt as to the defendant's guilt, not a fanciful doubt, not a manufactured one, but a real one grounded in the evidence, they were required by law to return a verdict of not guilty. The jury returned to deliberations. 3 hours later, they sent a note. They had reached a verdict. The courtroom was completely still when they filed back in. Stephen Pratt stood, hands at his sides, and looked at the jury. Marcus Green stood beside him. The prosecutor sat with his pen held motionless over his legal pad. The foreperson, a woman named Judith Crane, a retired high school principal who had taken notes throughout the entire trial in a small spiral notebook, unfolded the verdict form. She looked at it. She looked at the judge. She read, "On the charge of murder in the first degree, we, the jury, find the defendant not guilty." Stephen Pratt sat down. He did not celebrate. He did not make a sound. He put his face in his hands and stayed there for a long time. Marcus Green placed one hand briefly on his shoulder. The prosecutor gathered his files in silence. Judge Sutton thanked the jury for their service, noted that the case had presented unusual procedural circumstances which the court would review in due course, and closed the proceedings with a quiet efficiency that felt somehow appropriate for a verdict that had been as complicated as everything that preceded it. Outside, the courthouse Victoria Cross was waiting on the steps. She had not been inside. She had not been permitted to be. She was no longer counsel of record, and the professional situation was sensitive enough that her presence in the gallery would have been inappropriate. But she had been standing on the courthouse steps since. The jury started deliberating, and she was there when the doors opened and Marcus Green walked out. He saw her. He nodded once. She nodded back. The investigation into Daniel Cho's embezzlement was opened formally within the week, based on Frank DeLuca's testimony and the financial records entered into evidence. The $4 million was never fully recovered. A significant portion of it had been moved offshore and disappeared into structures that investigators spent 18 months trying to trace. 2 of the firm's corporate clients filed civil suits. The firm itself did not survive the year. Stephen Pratt did not return to accounting. He sold his interest in what remained of the practice and moved out of Chicago. He has not spoken publicly about the case or about Victoria Cross. Victoria Cross returned to her office the Monday after the verdict and began preparing for her next trial. When a journalist called to ask how she felt about the outcome, about the fact that the man she had withdrawn from defending had ultimately been found not guilty, she said one sentence and ended the call. The system worked. It had, not smoothly, not without cost, not without a 2 a.m. phone call and an emergency flight to Seattle and 11 hours of jury deliberation, and a question sent to a judge that exposed just how difficult it is to find certainty in a world full of people who tell the truth too late. But it worked. That is what sweet justice is about. Not the perfect cases, not the clean ones. The ones where the truth is buried under the wrong choices people make when they are afraid, and where the courtroom at its best digs it out anyway. Subscribe to Sweet Justice and never miss a case. Share this with someone who loves a story that goes somewhere unexpected. We will be back very soon with another one. We will see you then.